Hello viewers, in the last session we discussed lesson 2. In lesson 2 we discussed the procedure of incorporation of a company. In this session we are going to discuss lesson 3, that is promoters and lifting up of a corporate will. The objectives of the lesson are to explain about the position of promoter and his duties. The reader will learn the characteristics of a company. The reader will appreciate the circumstances for disregarding the corporate personality. The lesson 3 is divided into 6 modules. Module 1, functions of a promoter. Module 2, duties of a promoter. Module 3, characteristics of a company. Module 4, lifting or piercing the corporate wheel. Module 5, statutory interpretations. Module 6, distinction between sole trading concern and company, partnership and company. What are the functions of a promoter? The main functions of a promoter can be summarized as follows: to conceive an idea of starting a business and explore its possibilities, to get necessary number of persons for starting a company, to prepare the necessary documents for filing with the registrar of companies, to enter into preliminary contracts with third parties on behalf of unincorporated company in connection with the formation of the company, to pay preliminary expenses, to arrange for loans and other types of financial assistance from the various financial institutions. Promoter and pre-incorporation contracts. Company cannot be sued on pre-incorporation contract. Sometimes contracts are made on behalf of a company even before it is duly incorporated. But no contract can bind a company before it becomes capable of contracting by incorporation. Thus, for example, in English and Colonial Produce Re 1906, 2 Chancery 435, Court of Appeal, at the request of the promoters of a company, a solicitor prepared the memorandum and articles of association of a company, paid the registration fees and got the company registered. The company was not held bound to pay for the services and expenses of the solicitor. The company could not be sued in law for those expenses inasmuch as it was not in existence at the time when the expenses were incurred and ratification was impossible. Company cannot sue on the basis of a pre-incorporation contract. Company is also not entitled to sue on pre-incorporation contract. A company cannot by adoption or ratification obtain the benefit of a contract purporting to have been made on its behalf before the company came into existence. This was held in Natal Land and Colonization versus Pauline Colliery Syndicate 1904, Appeal Cases 120. One N company agreed with a promoter of the P Syndicate Limited before its formation to grant a mining lease to the syndicate. The syndicate was registered and discovered a seam of coal. N company refused to grant the lease. P Syndicate sued N Company Limited to enforce the lease agreement which it entered into through its promoter before it was incorporated. It was held that there was no binding contract between the two companies. The reason being P Syndicate was not in existence on the date when its promoter entered into contract with N Company. Promoter's personal liable. For all pre-incorporation contracts, promoters are personally liable to the third parties, and the leading case on this point is Kellner versus Baxter, 1866, Law Reports, 2 Crown Proceedings, page 174. The facts of the case were that the plaintiff intends to sell certain barrels of wine to the unincorporated company, and the proposed directors of the company entered into contract on behalf of the unincorporated company with the plaintiff and also took the delivery of the stock personally. It was held that as they had contracted on behalf of the principal who did not exist, they having received the wine must pay for it. Promoter is also not liable in case the third party entered into contract with the unincorporated company only, where the contract is purported to be made by the company itself. It cannot be enforced by or against the agent through whom the company contracted, because nowhere in the contract the agent's name was not mentioned. The leading case on this issue is Newborn versus Sensolid, Great Britain Limited, 1954, 1 QB 45. The plaintiff was a promoter and prospective director of a limited company named Leopold Newborn London Limited, entered into contract on behalf of the unincorporated company with the defendant XYZ company to supply certain goods after incorporation of the company. Nowhere in the contract the plaintiff's name was mentioned, but mentioned only the unincorporated company's name only as a party to the contract. On incorporation by Leopold Newborn London Limited, it wanted to perform its obligation, but the other party to the contract, XYZ company, committed breach of contract. It was held that the promoter and prospective director of the company cannot sue the defaulter because he was not a party to the contract, and the company also cannot adopt and enforce the contract because on the date of entering into contract, the company was not in existence. In case of all pre-incorporation contracts, in case the company after incorporation makes a fresh contract, the liability of a promoter shall come to an end. In case the unincorporated company does not make a fresh contract after incorporation, the promoter will become personally liable to third parties for all pre-incorporation contracts. Pre-incorporation contracts and Indian law. Section 15H and 19E of the Specific Relief Act 1963 deal with this issue. When the promoters of a company have, before its incorporation, entered into a contract on behalf of the company and for the purpose of the company, and such contract is warranted by the terms of the incorporation, specific performance may be obtained by or enforced against the company, provided that the company has accepted the contract and has communicated such acceptance to the other party to the contract before he revokes his offer. For the purposes of the company means on behalf of the company, and warranted by the terms of incorporation means within the object clause of the company. Now we will discuss the duties of promoter. In Vali P. Rao versus Sri Ramanuja Ginning and Rice Factory Private Limited, 1986, 60 company cases, 568, Andhra Pradesh High Court, it was observed that a promoter is neither an agent of the company nor a trustee of the company. He occupies the position of a quasi-trustee. Hence, a promoter stands in a fiduciary position in relation to the company. The relation between the company and that of the promoter is that of uberrime fide, that is utmost good faith. It means he should not make any secret profit while acting as promoter in incorporation of a company. The position of a promoter in incorporation of a company was discussed in Erlanger versus New Sombrero Phosphate Company, 1878, law reports, 3 appeal cases. P, a promoter with his friends purchased a phosphate mine for 55,000 pounds. Then P with his friends incorporated a company. P named 5 directors, and out of 5 directors, 3 directors were completely under the control of P. After incorporation, the 3 directors who were the friends of P purchased the phosphate mine for 1,10,000 pounds for the company. The purchase was adopted by the shareholders of the company in the first general meeting, but the real circumstances were not disclosed to the shareholders. After some time, the company failed and the liquidator detected the fact that the promoter P made a profit of 55,000 pounds by selling the phosphate mine to the company. Promoter contended that the directors were having complete knowledge about the transaction. It was held that the directors were not independent and completely controlled by the promoter, and hence, in those circumstances, the promoter should disclose the same to the shareholders in the first general meeting, and he failed to do so, he was liable to return the profit that he made by selling the property to the company. The principle is, the law did not forbid the promoter to make the secret profit, but the non-disclosure of the profit to the independent directors of a board, otherwise to the shareholders in the general meeting, and once they permit, he is allowed to retain the profit, otherwise he should return the profit that he earned to the company. Now we will discuss the characteristics of a company. The first characteristic is separate legal entity. Once the company is incorporated under the Act, it is to be treated as a separate legal person in the eye of law. The company can enter into contracts with its shareholders and debenture holders. This principle was firmly established in a classic case of Solomon versus Solomon and Company Limited, 1897, appeal cases, page 22. Solomon was doing sole trading shoe manufacturing business. He incorporated a public company by name Solomon and Company Limited. In the new company, he, his wife, his 4 sons and his daughter were the shareholders in the company. He sold his business to the company for £40,000 and he received the consideration in the following manner: £20,000 worth equity shares, £10,000 worth secured debentures, £10,000 in cash. After some time, the company went into liquidation and the assets were found to be worth £6,000 and its liabilities amounted to £17,000, of which £10,000 due to Solomon, a secured debenture holder, and £7,000 due to unsecured debenture holders. The unsecured creditors contended that the company is merely a sham and Solomon was the agent of the company and hence they should be paid in priority to S. In the lower court, Justice Wagon William observed that the company was not having a separate personality apart from Solomon and hence the liquidator should give priority to unsecured creditors. In appeal, the Court of Appeal also held the same. Solomon further appealed to House of Lords and Lord Magnaten and Lord Halsbury and Lord Herschel held that once the company is incorporated, the company should be treated as an independent legal person and the personality of the members of the company is different from the personality of the company and hence Solomon should get priority over the unsecured creditors. The second characteristic of a company is limited liability. The liability of a member in a company is limited to the extent of value of shares purchased or agreed to be purchased or limited to the extent of amount guaranteed by him. In exceptional circumstances, by special contract with the company, he can make his liability unlimited. The third characteristic of a company is perpetual succession. It means that company's existence persists irrespective of the change in the composition of its membership. It is created by a process of law and can be put to an end to only by process of law. The fourth characteristic is the common seal. A company is an artificial person and hence it should enter into contracts through its agents called board of directors of the company and all such contracts must be under the common seal of the company. The next characteristic is transferability of shares. In case of a partnership, a partner cannot transfer his shares to the outsiders. But in case of a company, as a general rule, he can transfer his shares freely and the transferee can become member of the company. The next characteristic is separate property. Once the company is incorporated, the property of the company is the property of the company only, but not the property of the shareholders. The company is the real person in which all its property is vested. In Macora versus Northern Insurance Company, it was held that even though a person was the owner of all the shares of the company except one, and he was also a substantial creditor of the company, when he insured the company's properties in his own name, it was held that he was not entitled to claim the insurance money, the reason being he was not having insurable interest in the company's property. Citation 1925, Appeal Cases 619. The next characteristic is capacity to sue. A company can sue and be sued in the name of the company. The next characteristic is professional management. The shareholders may be scattered throughout the world, and it is difficult for them to manage the affairs of a company, and hence they elect some competent professionals to manage the affairs of the company, and they are called the board of directors of a company. We are going to discuss is lifting or piercing the corporate veil. The general rule is that once the company is incorporated, it is to be treated as a legal person in the eye of law, and the personality of the company is the personality of the company only, but not the collective personality of the shareholders of the company. According to law, once the company is incorporated, between the company and the members of the company, a screen will be formed. It is called corporate veil, and because of this corporate veil, the company assumes separate corporate personality. The term personality is derived from the Latin word called persona, that is the name of a mask worn by a Greek artist on the stage. As a general rule, the courts do not lift the corporate veil or pierce the corporate veil. Because of this advantage, some people started misusing this principle for fraudulent purposes, and thus it became necessary for the courts to lift or pierce the veil and look at the persons behind the company who are real beneficiaries of the corporate fiction. This topic may be discussed under two heads. One, judicial interpretation, and the second one is statutory interpretation. The first head, judicial interpretation. In this, the first example is determination of a character of a company. During the period of war, in case the company is completely controlled by enemy country people, then the court may declare the company as an enemy company. In Daimler Company Limited versus Continental Tire and Rubber Company Limited, 1916, 2 appeal cases 307, a company in Germany was manufacturing tires and tubes. To sell its products in England, the German company incorporated another company in England under English Companies Act. Majority shares in the English company were held by Germans. The English company sold some stocks to British government on credit basis. During the First World War, the English company started an action for recovery of trade debt. It was held that the English company was controlled by Germans, and thereby it assumes enemy character, and therefore the company was not allowed to proceed with the action during the period of war. The next illustration is the fraud or improper conduct. When the doctrine of separate personality is used for some fraudulent purpose, then the courts may disregard the corporate personality and lift the corporate veil. In Guilford Motor Company versus Horn, 1933, Chancery, 935, Court of Appeal, where XYZ Company appointed Mr. Horn as its managing director for certain period on a condition that he shall not at any time while he shall hold the office of a managing director or afterwards solicit or entice away the customers of the employer company. After completing the period of contract of employment, he started his own business by incorporating the company and started enticing the customers of his previous employer. When the previous employer brought an action against Horn, it was held that the company was a mere clock or sham for the purpose of enabling the defendant to commit breach of his covenant against solicitation of customers of previous employer. The court passed an injunction order against Horn not to continue the business by lifting the corporate wheel. The next illustration is for the benefit of revenue. The court may disregard the corporate personality when it is used for tax evasion. In Sir Dinshaw Manekji Petit, Re. AER 1927 Bombay 371, as a wealthy person, to avoid income tax, formed 4 private companies. Whatever payments he was supposed to receive from third parties, he asked them to pay to the companies with a view to reduce tax liability. Again, these companies transferred these payments to S as a pretended loan. It was held that the companies were formed with a view to avoid the tax liability, and the 4 companies were nothing but the assessee himself. Now we will discuss the second head, that is statutory interpretation. The first example is number of members below statutory minimum. This is section 45 of the Companies Act 1956. When the company carries on business beyond 6 months, even after its members reduce to 1 in case of a private company and below 7 in case of a public company, every member who carries on business after 6 months with knowledge about the reduction of members less than statutory minimum is severally liable for the whole of the debts of the company contracted during that time. The next statutory provision is failure to refund application money. This is discussed in section 39 of the Companies Act 2013. The company should return the application money to the applicants in case the shares are not allotted to them. The Act lays down that it should return within 130 days from the date of issue of prospectus, otherwise the directors are personally liable to return the application money with interest. The next statutory provision is misdescription of company's name. This is discussed in section 12 of the Companies Act 2013. When the company's name is not mentioned properly, the concerned officer who is in default will be personally liable to pay fine. Next statutory provision is fraudulent trading. In case the company is incorporated for a fraudulent purpose, then every member who is a party to the business with knowledge will be personally liable to the debts of the company. The next statutory provision is holding and subsidiary company. This is discussed in section 2 subsection 46 of the Companies Act 2013. According to the Act, every holding company at the end of the financial year should file not only its final accounts but also the final accounts of all its subsidiaries with the concerned authorities. Distinction between sole trading concern and a company, partnership and a company. The main disadvantage of doing business in the form of a sole trading concern is that sole trader's liability is not only unlimited but also personal liability. The main disadvantage of doing business in the form of a partnership is the liability of a partner is not only unlimited but also joint and several liability. In addition to that, there is personal liability for each partner. As a general rule, the liability of a member in a company is limited. In case of a company, a member can transfer his shares, whereas in case of a firm, as a general rule, he cannot transfer his shares. The provisions of the Act shall apply to companies incorporated under this Act or under previous company laws. It is also applicable to insurance companies, banking companies, power generation companies, any other company governed by any special act for the time being in force. The Companies Act is applicable to the above mentioned companies except in so far as the said provisions are inconsistent with the provisions of the Parent Act. Dear viewers, in this lesson, we discussed the promoter and lifting up of a corporate will, the functions and duties of a promoter, the characteristics of a company, and the circumstances under which the court can disregard the corporate personality that is lifting up of a corporate wheel. I hope you enjoyed this session and we will meet in the next session. Thank you one and all.